Hi everyone, and welcome to our webinar today on working with suppliers and distributors, understanding your legal obligations. My name's Olivia and I'm a lawyer in our commercial team here at LegalVision, if I haven't met you before, and I'm joined today by my colleague Stephen, who's also a lawyer in our commercial team. We'd like to start first with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us here today. Before we begin, there's a couple of housekeeping items. So you'll be emailed a copy of this webinar recording for you to refer back to. We'd love you to submit any questions you have along the way in the chat box in the webinar. And we'd love you to also please complete a survey after the webinar to give us some really valuable feedback. So today we'll be discussing dealing with overseas distributors and suppliers. We'll be focusing our discussion on overseas distributors and suppliers, but will certainly be relevant for those in Australia. Protecting your intellectual property, your consumer law obligations, what to put in your contracts, and then we'll obviously finish with a Q&A. So at the end of the webinar, we'll be answering some of your questions, as we've said, so please submit them through the chat function and we'll hopefully get to them at the end. So let's kick off. Stephen will start by talking to us about the pitfalls when dealing with overseas distributors.
Thanks, Olivia. Distributors are an important part and can play a crucial part, in the early stages of a business's growth. So when we mean distributors, we talk about sort of the intermediaries that you would use between yourself as a supplier of goods and between you and your customers, and those might be your retailers or even other distributors. Distributors play a really important role in sort of extending your reach into a particular market. Now, it could be a market where you don't have a company, where you don't have staff, and they have this, or even where you don't speak the language, and they help you to sort of grow your business goodwill and drive the value that your brands bring, which is why it's important when you're dealing with overseas distributors especially, is that you consider your future market growth plans. Your business needs are likely to change over time. And so it's really important before signing a contract with a distributor that you actually sit down and assess how long are you planning to work with that distributor for? At what point do you think you might want to enter into the market? Are you already in the market? Is quite a common one. A lot of our clients operate on e-commerce platforms and want to continue to be able to do so and use their distributors to, I guess, expand their presence in brick and mortar stores. And because those needs can change over time, forward thinking and planning is a must. And that's where we see a lot of pitfalls when our clients come to us with problems, is that sort of they've outgrown the distributor and they haven't determined, they don't have a contract and they don't know how to get out of it. Maybe the local laws are a bit more difficult when it comes to sort of parting ways. So it's really important to consider that. And along that sort of same note, working out the territories and the channels that you want your distributors to play in. Now, for example, you might not be in the US, you really want to get into the likes of Walmart and Target, so you might assign a distributor that entire territory, and that's fine. But then you might decide, hey, Amazon's really lucrative, I want to carve that channel out for myself. And so when we talk about channels, we're talking about things like grocery, mass retail, and it's really in the likes of those. And so it's really important to know sort of where you want those distributors to operate and narrow the scope as much as possible. And that also follows on through things like exclusivity. So when you're enter into an exclusive agreement with your distributors, it essentially can lock you out of the market. And we see a lot of clients who come to us with these sort of 10, 15-year exclusivity agreements, realize that they want to be able to go into the market. It's more lucrative because they can get increased margins by going direct to retail, for example, and they simply can't because of a very strong exclusivity clause that they've agreed to. So the territory and channel management piece is super, super important, and especially when you grant exclusivity really needs to be considered, and how long you grant it for. A lot of the time you've never worked with this distributor previously, and so maybe granting exclusivity off the bat isn't the wisest choice. Maybe give them a trial, set it for 12 months, reassess, and just mitigate that risk. And then finally, marketing and brand reputation is super important, because that's where the value is driven from your brands. your distributors will be the ones going to retail, going to customers and representing your products, representing your services or brands. And you need to have strict controls to make sure that their activities are in line with your expectations. Now, those can be things like brand guidelines, determining who's responsible for creating content, when content can be used, things like translation, compliance with local laws, and much more. Especially if your distributor's working on e-commerce, those can be very quick to get out of control, and sort of setting the scope there too is really important. And we'll touch on more on how you can protect your brand and your marketing in sort of some of the next slides. But for now, Olivia is going to talk to you about some of the pitfalls when dealing with suppliers.
Thanks, Stephen. So certainly in relation to overseas suppliers, there's some common pitfalls, some of which are similar to what Stephen's already discussed, but these are slightly more specific to an overseas supplier arrangement. So if you can see in this diagram, here we're talking about an overseas supplier who is selling you goods which you're importing into Australia. So you're the retailer. You may be sort of on selling directly to the customer, or you may be acting as a distributor and sort of distributing to further distributors within Australia. So a few things to consider. Firstly, practically from a due diligence perspective, this isn't necessarily a legal point, but obviously when it comes to disputes with overseas suppliers, it can be difficult to enforce your contractual rights, expensive, time-consuming. So practically speaking, it's really important to do your due diligence on the supplier that you're looking to work with. Some of the practical things and the sort of the areas where you need to do your due diligence is considering the product safety, the reliability and the quality of that product that you're importing, but also sort of confirming whether they have any other sort of overseas distributors or importers you can chat to about their experience, and also sort of just doing a general research as to whether they've been involved in any court cases or sort of any other litigation that may be of interest to you before you agree to work with them. Compliance with local laws. So sort of when you're importing into Australia, there's obviously various laws that you'll need to comply with. And your overseas supplier may not have considered that when they have, packaged the product and made the product and manufactured it for you. So a few things to consider. Ultimately, if you're going to be selling the product in Australia or distributing that, you may be considered, or you're very likely to be considered the supplier or the manufacturer or both under the Australian consumer law. So you'll need to consider those local laws when importing that product. And before you do so, you should ensure that the product can comply with those local obligations. Some common areas would be product safety, labeling of the products, how you can advertise the product, various product warranties under the consumer law, and industry-specific legislation. So if it's a therapeutic good, you may need to consider the therapeutic goods legislation, and there's sort of various other industry-specific legislation you should consider. Your supplier may not have been aware or done their own research as to the product in light of those local laws. So that's going to be something that will often sit on your responsibilities. Shipping and delays. So certainly COVID has brought this to light even more so than before. Shipping and delays is, unfortunately an inevitable part of importing goods into Australia, but it's important from a legal perspective that you can sort of try and mitigate the risk when it comes to shipping and delays. Ensuring it's really clear who's responsible for shipping, and also considering what could be your practical losses if there are delays. So if it's something within the control of the supplier and they don't ship your goods on time, but you've got separate contracts with other distributors or consumers in Australia that you need to adhere to, that needs to be quite clear in your contract so that you're basically sort of understanding what your potential losses are if you can't meet those obligations. Often when we're dealing with overseas suppliers, it's common to use Incoterms, and they're essentially a set of universally agreed commercial rules which govern sort of the shipping and sort of the risk in relation to the shipping of goods overseas. So it's a clear way of attributing the responsibilities for cost and risk when shipping between different countries. So important to consider whether that's you should use an Incoterm in your contracts, and certainly picking the right one is really important. Intellectual property protection, Stephen's going to talk about this in the next slide, so I won't go into too much detail, but ensuring that you've got all the required registrations in place, considering what intellectual property is associated with the product as well. So we're thinking here about the branding, the trademarks, the product design, any other materials that come with the product could all be intellectual property and really, really valuable for your business. So considering whether it needs to be registered, and obviously ensuring that the arrangement is clearly articulated in a legal contract as well with your overseas suppliers. That's definitely a pitfall we tend to see. And then enforcing contractual rights. So as I've sort of touched on before, it can be difficult to enforce a contract with an overseas supplier. So obviously best to avoid those disputes before they arise. However, firstly, just considering sort of what law will govern the contract between you and your supplier. Will it be the overseas jurisdiction, in which case you'll likely need a local lawyer in that jurisdiction to advise you if there's a dispute? But if it is in Australia and it's governed by Australian law, ensuring that if you sort of need to enforce that contract and get a judgment against that overseas supplier, it can sometimes be difficult to enforce that judgment overseas if they don't have a presence in Australia. So with few exceptions, China, can make it quite difficult to enforce your rights, and they certainly are unlikely to enforce a foreign court judgment. However, they are more likely to enforce a foreign arbitration award. So having those mechanisms for dispute resolution in place is also really important. So Stephen will now talk in a little bit more detail about protection of IP.
So as we've sort of, I guess, already alluded to, intellectual property is I think the most fundamental thing. If you're going to get anything right in your business, it's how to protect your intellectual property, because at the end of the day, that is what drives the value, and that is what drives, I guess, things like consumer recognition when it comes to your products and your services. Now, there are different ways you can protect your IP. Trademarks are one of the most common ones that we see. So those are to protect things like your brand names, maybe if you've got a particular slogan, and things like that. Patents protect how your products work. So if you've got quite a novel or inventive product, then we can obviously assist you with, and to plug sort of my IP colleagues here, we help with all these sort of things as well. So if you haven't already and you haven't had a chance to speak to our IP team, then I highly recommend you do that. So patents protect how things work. Designs protect how your products look. So if you've got a very unique looking product and you want to protect the aesthetic function, so it's the aesthetic of it, then a design is probably the way to go. And also domain names are really important to consider. They're not typically, a lot of the time they're forgotten as IP, but domain names are really important because it's where your consumers will go to get information. And also when you're dealing with, especially overseas distributors, you want to control the local domain name. So if you're appointing a distributor in France, you might want to control the .com.fr domain name for your business to make sure that, if there's a dispute or a falling out with your customer or distributor, that you have control over that domain. Because while there are processes to sort of retrieve those, they are time consuming and likely expensive, and you can just avoid yourself the headache from getting these things right in the first instance. It's also good to consider having not only IP in Australia, but also wherever you do business. So that's where you sell products, but also where you get them made. And a lot of the time, if you're working with an overseas supplier, especially China, a lot of the factories are quite conscious of infringing things like patents and designs. If you can point to a Chinese IP filing, it's just helpful to sort of, I guess, deter maybe some of the counterfeiting that can go on, especially in a lot of those factories. It's also important too, because I've had a client before that didn't register a trademark in a country where they were distributing. So they had a distributor that appointed in Brazil. They never filed the trademark. The distributor looked online and saw that they hadn't done it. And so the distributor decided to do it themselves. And it became a sort of a 4-year expensive process to try and get that trademark back from the distributor to the client. And then e-commerce marketplaces, and I touched on this briefly before, but they have some very good brand protection tools if you have registered trademarks. So for example, Amazon has its brand protection or brand registry function, where you can lodge your international trademarks and you can perform sort of counterfeit takedowns against knockoff goods. I had a client that had sort of set up Amazon brand registry in a lot of countries, along with their counterparts in sort of Alibaba and Taobao and eBay, and they were taking down over 10,000 counterfeit listings per year. And so it really shows you the importance of those tools and how they can actually help you to sort of keep the market as clear as possible to maximize your bottom line. And in terms of setting expectations on how distributors can use your intellectual property, I spoke about brand guidelines. A lot of our clients will have these sort of guidebooks, do's and don'ts when it comes to how the logo should be used or certain things that you can say about the product. Really important too, because representations by distributors and customers will impact your reputation in the market, especially later on if you decide to go into that market yourself. You also need to consider who's going to be creating content. So if you are appointing a distributor in a country where English isn't the primary language, you might not be best equipped to handle the translation, but you're going to want some sort of warranty or undertaking from the distributor as to the accuracy of translations, and also that any marketing materials that they create or modify are compliant with local laws, because it is likely going to be outside your sort of ambit or your expertise to be able to handle that. And why not put some of the cost on the distributor? They're making money off it. It shouldn't all be at your expense, and it's a partnership at the end of the day. So working those things out are really, really important. And I mean, I think if you have any questions on this, again, just to reiterate, please book a time with our intellectual property team. I cannot stress enough how important this is. Liv's going to talk about now a bit more about your Australian consumer law obligations and when those will apply to you and what that might mean for your business.
Thanks, Stephen. So yeah, turning our minds now to Australian consumer law obligations. So certainly relevant for when you're importing goods into Australia for sale. Obviously there'll be local laws that you need to consider if you're exporting goods into local jurisdictions, but we'll focus here on Australian consumer law obligations. So firstly, it's really important to consider whether you would fit the definition of a supplier or a manufacturer, or both, under the Australian consumer law. Now, a supplier, sort of generally speaking, is someone who supplies or resupplies by way of sale, exchange, lease, hire, or hire purchase to a consumer, as a consumer is defined under the Australian consumer law. So if goods are under $100,000, with a few exceptions, they'll generally be considered a consumer. Separately, manufacturers are also defined very broadly under Section 7 of the Consumer Law. And a manufacturer is a person or business that makes or puts product together or has their name on the products. Now, this would also include the importer if the maker does not have an office in Australia. So if you're importing goods into Australia, the manufacturer, the person who's actually made the products, does not have an office in Australia, you would very likely be considered the manufacturer for the purposes of the Australian consumer law, or even both. So the importer as well as the manufacturer who has made the products would be considered the manufacturer and can be concurrently held liable under the Australian consumer law. So certainly come to us if you're not sure kind of where you fit in that definition. But just having a look at the table, this table sort of talks a little bit about what those consumer guarantees are, and they differ slightly depending on whether you're a supplier or a manufacturer. So for a supplier and a manufacturer, you'll need to ensure the goods are of acceptable quality, that they match the description provided to the consumer, and that any express warranties, so any promises you make about what the good will do, is honoured. So those apply to both. Now, as you can see, there's also separate warranties for a supplier. So the goods need to be provided or sold to the consumer with clear title, free of encumbrances, with a right to undisturbed possession. So no one's going to take it back from you. And are fit for the disclosed purpose that the supplier has disclosed. and match the sample or demo model. So obviously, if you're in a store, if you've got a demonstration model that you've shown the consumer, it needs to match that model. The manufacturer will also have an obligation to guarantee the availability of repairs and spare parts. So if you're thinking, a lot of electronic goods, for example, such as, fridges, other types of household goods, they'll need to have availability of spare parts for a reasonable amount of time, and the manufacturer has that responsibility. So when it comes to considering your obligations, obviously, if you are in breach of those obligations, there may be a remedy that's available to the consumer. And again, these will differ depending on whether you're a supplier or manufacturer, and also whether the defect that is in relation to the goods is a minor or a major defect. So we can certainly assist in ascertaining what that remedy would likely to need to be under the consumer law in a case-by-case scenario. However, generally speaking, the standard remedies for a supplier would be repair, replacement, or refund, and compensation for damages or loss. Now, the supplier can't, if you as a supplier have, a consumer comes to you with an issue with a good and you're entitled to provide a remedy, you can't tell them to sort of go away and deal with the manufacturer. You have an obligation to deal with that yourself. And there's what's called a manufacturer's indemnity. So under the consumer law, the manufacturer must indemnify or pay the costs of the supplier if the supplier is entitled, must provide a remedy to the consumer under the consumer law for a failure to meet one of those top 3 consumer guarantees. So that indemnity is in place and that can't be contracted out of. So you need to be aware that, from a supplier perspective, you're entitled to ask for those costs under a manufacturer's indemnity. And as a manufacturer, obviously, you're entitled to or you must abide by that request if it's applicable to you. So I suppose another thing just to quickly touch on, and obviously get in touch with us if this is applicable to you. If you're providing another, a manufacturer's warranty or a separate warranty against defects, please come to us, and we'll need to ensure there's lots of laws under the consumer law around the way in which that needs to be drawn up and represented to the consumer. So please come to us as well if you're providing a warranty against defects to your consumer, and we can ensure that that's all prepared correctly for you. So let's get on to sort of what to put in your contract. So Stephen will touch on the first of those.
Thanks, Olivia. Price adjustments is quite an important one for distribution agreements. As you might be aware already, costs can increase over time, and that might be things like shipping, foreign currency exchange, raw materials, and the like. Now, that's not something you probably want in your supply agreements, because if you've negotiated a really good price, you sort of want to lock it in for as long as possible. But when working with your distributors, you want to be able to pass on any sort of supply chain costs and reflect that in your pricing to sort of maintain your healthy margins. Now, a lot of clients will have clauses that tie to the consumer price index. Just a key note there is, if you're not already aware, is that Australia is actually going to introduce also a monthly CPI index as well as a quarterly indicator. So if any of your contracts do refer to the CPI index, it might be worthwhile to chat to us about updating those to make sure you're referring to the right one, because if there's any ambiguity, then there's an argument as to which one might apply, and the monthly one is likely going to be more volatile than the quarterly figure. So price adjustment clauses are really important. Product recalls for both ends. So if you're sourcing goods from a supplier, you're going to want to make it really clear who's responsible for what in the event of a recall. Now that can be a mandatory recall if it's required by government, or a voluntary one. Say for example, there's a labeling issue and you want to remedy it throughout your supply chain. Cost allocation is really important, because some end customers, some retailers may have specific clauses in their agreements that deal with, that you have to, or your distributor has to, pay their lost profits and lost revenues, and you need to make sure that you accurately carve your liabilities in the event of a recall, and your responsibilities to the maximum extent permitted by law. We've talked extensively about exclusivity and channel management. It's not something you typically see in a supply agreement. Sometimes if you've negotiated sort of a high value or a really lucrative contract that the supplier is interested in, then they may agree to it to be on an exclusive or non-competitive basis. Generally, we don't see it though. And then distributors, obviously, we've talked about the importance of why you'd want those in your contracts. And I think just as a general rule, even if your distributor is going to be non-exclusive, you should always specify that. There may be some countries where if the contract's silent about exclusivity, then it may be assumed to be exclusive. As Liv touched on earlier, Incoterms are those international commercial trade terms that deal with things like when risk transfers and sort of shipping and delivery terms. Really important that you use those correctly. Some of them are only suitable for certain types of transport. For example, 4 of them are only to be used when dealing with sort of sea or waterway transport. And also they don't deal with things like transfer of ownership and goods. So those need to be dealt with separately. We also see a lot of clients that will put Incoterms in and use them incorrectly, or they don't specify sort of the exact delivery address or collection address where the goods are meant to be picked up from, and that they also sort of use other clauses that conflict with the Incoterm. So for example, they might use a sort of a delivery Incoterm, but then write a different delivery clause that conflicts with what the Incoterm would normally say. So it's really important that those are correct as well. And then lastly, all these are pretty standard. You probably want to have your price in your contract so that the parties know what's being paid. Confidentiality about your financial information and your market plans, because a lot of the time your distributors, depending on the industry, may be working with some of your competitors. Disputes and governing law, particularly important when you're doing international business. Arbitration can be quite expensive. If you can opt for mediation, then we recommend it. It's also a lot quicker. And then governing law, if preferable, try and get it in Australia. Certainly, as Liv said, countries like China and sort of places that don't operate on a common law or English framework can be a lot harder to exercise your rights in. So again, which is really important to get those right. Then Liv's going to talk about some of the other elements in your contracts just quickly.
Great. So, yeah, intellectual property is one we've already discussed quite extensively, but ensuring that, obviously those registrations take place, and then similarly in the contract, we're sort of touching on what all the intellectual property could be, and who owns the intellectual property, what license is granted to the other party in respect of that intellectual property and for how long. And then also sort of things around, goodwill that could be, claims during the sort of the term of the agreement. So if your distributor is overseas, they sort of grow the brand's goodwill in that particular country. You don't want them to be able to claim that they own that goodwill or can benefit from that goodwill. So that's often sort of a unique clause to those types of distribution agreements in respect of intellectual property. Indemnities and liabilities. So, obviously this is kind of where a lot of the negotiation is done, and it will depend on where you sit in the transaction as to how we draft these indemnities and liability clauses. But ultimately, we want sort of both parties to be responsible for sort of any loss or sort of damage that's caused as a result of the relationship. So we need to attribute loss correctly, limit liability as much as you can under law as well for yourselves. So we'll always aim to do that in the contracts, and be clear as to what type of loss you would be liable for, whether that's direct or sort of indirect or consequential losses as well. Just quickly, quality control. So not so important for distribution where you're shipping or exporting goods to the distributor, but certainly where you're importing goods from a supplier, you need to sort of have a process in place for if those goods are defective once they're shipped to you. So if you receive a shipment of goods, they're damaged, what's the process then for getting the supplier to provide a remedy, whether they need to either provide a refund or sort of quickly ship out a new batch of goods to remedy that defect. That's certainly very important to consider in supply agreements. And then lastly, insurance. So there's, various types of insurance that could be applicable here. Again, it will depend on where you sit in the transaction. But certainly insurance relating to shipments and who's responsible for that. So that could be dealt with in the Incoterm. or it may not be. And then separately, sort of insurance in relation to the products themselves, product liability insurance. What happens if something goes wrong with the products? What insurance do you need the other party to have backing them up, so that if you need to sue or claim losses under, the contract, you can feel slightly more confident they'll have the money backing them up in an insurance policy to pay for those losses. So that's a bit of a summary of what to put in contracts, and certainly that's our job to ensure that you've got a well-drafted contract in place. So please do book in a call with us to either get a contract reviewed or drafted for you in relation to either of these matters.
So just some high-level takeaways. Obviously, always have a contract in place. I think what a lot of clients forget is that contracts aren't just for use in disputes. A lot of the time, or the way I like to think of them is like a safety net. If you don't have a contract, the only option really is to go through a formal dispute process. But a lot of the time, disputes can just be resolved by having written terms, knowing what's agreed, and a lot of the time disputes are based on uncertainty or sort of not knowing what the obligations are, and so having those in writing can actually resolve a lot of disputes off the bat. Doing your due diligence, super important. As discussed, distributors and suppliers are going to make or break the success of your business, and so making sure that maybe get some references about them, get to understand how they operate, whether the way they operate aligns to your business, and maybe even some use cases, and I think again limiting the scope of any sort of exclusivity or term as a trial, maybe for a year, is really helpful as part of that due diligence process as well, and follows into risk mitigation strategies in terms of how you can limit the commercial risk when working with these third parties. And there are other things you can do as well. For example, structuring your payment terms with your suppliers to make them more favorable, or with your distributors to ensure constant cash flow, reporting obligations on your distributors so that you know what's going on in the market. And then also from a supplier perspective, getting samples and quality control rights and audits so that you can identify any defects or deficiencies with your products sooner rather than later when they're on the shelf and maybe there's a government regulator involved. And then finally, if you do get any certifications from your suppliers, and this ties into the quality control piece, always try and verify them as much as possible. A lot of clients will get a certificate from a foreign manufacturer and think, hey, this is great, they've got all these qualifications, but a lot of the time, not all the time, but a good amount of time, they are fraudulent or out of date. And most of the labs will have some form of verification check or process that you can go to. Take this, you type the certificate number in and actually verify that certificate is valid. So yeah, really important just to consider those things if you can take anything away from this call. We've also put together for you a commercial contract checklist. You can download that from the handout section in your webinar panel. Again, super important that you always check your contracts as your business changes. Contracts do become out of date quite quickly as your business evolves and grows. You've got access to a sort of unlimited consultations as part of your pro membership, so why not make the most of it? Even if you've got a question that's not related directly to distribution or suppliers, our team actually handles a wide array of commercial contracts. So encourage you to speak with us, even if you're not sure, even if you've just got an idea. You don't have to just come to us to get something drafted or reviewed. You can also just book in a time to say, hey, I've got a new idea. Do you think it has merit, or how would you suggest I approach this? Because a lot of the time can actually speed things up for you quite quickly if you get it right from day one. We also have an upcoming event that might be of interest to you around cybersecurity breaches and what your business's legal responsibilities might be. There's a link there that you can register in, and I'm sure you've been receiving some communications as well about that. So highly recommend you jump on that one. And then now we'll answer some of your questions. I see we had one question sent through around, if you have a distributor that you no longer want to work with, how can you get out of the contract? Again, it's a really common one that we get. We encourage you in that case, if you've got a contract, just book in time with our disputes team. Generally, the way you get out of a distribution arrangement, at least, is based on what the terms and termination rights are. So there may be sometimes, if it's a breach of contract claim, or there may be other remedies under Australian law that we can advise on. So yeah, fundamentally, I think the key takeaway here is just chat to us. If you're not sure about anything, that's what we're here for. Well, that's all for today. Thank you very much for joining us. It's been a pleasure to sort of share this information with you, and hopefully look forward to speaking to you soon.